has to go to a private meeting, Alita can make it go private. And as I understand it, we can go back to public. But to summarize, Marla has concerns that we can't go forward, or we may not be able to go forward just on a jurisdictional, looking at Rule 6, which is in her memorandum, and then also the statute itself, which is Section 2230.011 under the powers and duties of the commissions. So would anybody like to be, heard? Go ahead, Robert.
Thanks, Chair Marston. So I prepared some remarks, and for clarity's sake, I think we need to review this and it needs to go on the record. So our rules provide that the chairman or two commission members may call us into a special meeting. Further, a special meeting only requires 24 hours notice, but an agenda must be posted in advance, of which the executive director did not satisfy. We have received increasingly frequent complaints from the public about process and access, including at just this past meeting. I'm alarmed that for the purposes of scheduling this meeting, it apparently could not be expedited fast enough in the middle of a holiday week, no less. And there is no agenda. An agenda that is apparently supposed to have only one item of business, but what do we know? For there is no agenda. What shall we approve? The excuse for an unproduced agenda is, quote, "We are all working remotely during this health emergency and hope everyone understands the efforts involved," close quote. Increasingly during 2020, this statement or similar words have been repeated while the executive director increasingly enacted what can only be described as self-directed rules contravening established commission rules and procedure. Considering in just the last meeting, the executive director suggested we allow more time between meetings because a substantially decreased workload and caseload. The pandemic excuse feels excessive. Further, when email began circulating for a potential meeting, I asked a number of salient questions relating to why there is a need for a special meeting, the majority of which remain unanswered. I also stated that this process feels rushed. We are supposed to be acting as a quasi-judiciary body. It is therefore inexcusable for the opaque, rushed, and sloppy process that this meeting was even called. I'm also at a loss why the executive director's memo comes now and seems to highlight only rationale for her standing. It is unbalanced and not even a reflection of what the commission decided. With that said, Chair Marston, please explain why we are here, why this meeting is so necessary on an expedited basis, especially during Christmas week, no less, and why was my motion, and what was my motion exactly, and what does this memo have to do with my motion? Because there is no semblance between the two items. So if you'd please explain those few questions, and I have a follow-up.
Well, my understanding was the motion originally was that you wished that the commission would send a letter to the Supreme Court concerning their letter and asking them to come visit with us and explain the letter to us. That was my understanding of the last thing that we did. In terms of why we're doing it quickly, we believe, or I believe, that this is an issue that needs to be addressed. It can't be hanging out there forever, especially if we lack authority. We lack authority and we're going down a course of action that we have no basis for. I think we need to consider that sooner rather than later. But again, I appreciate everyone being here on short notice.
Yeah. Well, that was not my motion, and it appears to be a reframing of my intent. I know, Chair, that you were in an opposition to my motion. And so my concern today is that both you and our executive director failed to grasp the motion and the resulting 5-3 decision, something that I repeatedly attempted to clarify in advance of this meeting, but had no response from you and little response from the executive director. The executive director picked and chose what would be responded to. So to review, because I have both the chair and the executive director, I believe they both are misunderstanding the motion and decision. And when email traffic began, I previously urged the executive director to carefully listen to audio for what the motion was. And so among those components, Here are the following 5 key items which are not contemplated by the executive director in her memo. 1, this was a private conversation, i.e. executive session. 2, this is a conversation invitation only with opportunity to decline. 3, it is decidedly not a public communication under the rules, especially Rule 6, because that only deals with public communications, yet the executive director just chose to write a whole memo around Rule 6. 4, it is consistent with our process and procedure in meeting with judges and with outcomes unknown to the public. That's why we do it in executive session. That's why we have the policy and procedure in place. 5, we are extending caution on the side of the public rather than the Supreme Court that can take care of itself quite well. In fact, commissioners have presented have been presented and then presented criticism and questions regarding the Supreme Court's letter. We are here to serve the public, I have to remind all of us, not err on the side of protection of judges. In short, this has nothing to do with public communication related to Commission Rule 6, which the memo focuses on. Further, just because this process is believed by the executive director as not directly covered in statute, it is also not precluded in any manner under the rules or statute, something the executive director admits in her memo. We should all be aware that in prior years, this body has determined to approach Supreme Court justices as well as the presiding justice in much the same informal manner. This is fact. We've done that before. Let it sink in. We have made similar approaches. So we have precedent. None of this is mentioned in the unrequested executive director's unbalanced memo. I don't understand. Why would that be? Again, the commission decides, as it did with a vote, not the executive director. Just as many commission members have observed that the Supreme Court is outside of its normal practice in issuing their letter, it is this commission's duty to adjust to their activity, and review extraordinary action of judges, even if it is just an appearance issue. The executive director agreed with this earlier this year, and that resulted in the Chief Justice eventually admitting that there were appearance issues in prior communications. That was supposed to be non-jurisdictional, yet we found it jurisdictional, and then the Blumen Chief Justice admitted that it had appearance issues. So as observed by commissioners in the last meeting, we are the only check and balance on the Supreme Court. I am disturbed that now that this memo document has been produced to the public and the Supreme Court, their minds will likely become polluted by it and the executive director's bizarre reframing of my supposed intent, which I again state is not what this body passed, and will make it easier for the Supreme Court to decline an informal invitation due to their misunderstanding. A misunderstanding refused to be clarified by, as well as perpetuated by, the executive director. I'm going to be bold. And this pains me because in just the last meeting, I stated I trusted the executive director implicitly. I consider this undirected and misguided research irresponsible and interfering in this body's process. Further, since simple questions that would help identify why this special meeting was even required were reduced to a series of technical jousts between me and the executive director, and while I attempted to clarify perceived misunderstandings and point out technical shortcomings by the executive director, they were explained away by it's a pandemic. This is not the excellence I expect of this commission, not the excellence that is required from the public of which this body ultimately serves. And as I have said throughout this episode, this is not the exceptional excellent common to Alaska as a state when considered against all others in serving its citizens. That said, I've got a motion to make. I hereby move that Chairman Marston take this duty over from the executive director and complete it amongst coordinated drafting with other commissioners. We already voted on the motion resulting in a decision, and it is up to the chair to work with us in drafting the communication. I have demonstrated why Rule 6 doesn't matter. And I'm not buying her Rule 4 excuse at the bottom of her memo of why she has jurisdiction to put her nose into this business. Rule 4 further states that she is supposed to anticipate certain things, which we had plenty of time. That's why we tabled this whole discussion to the last meeting, yet that was not done. In any event, the motion again, I'll repeat it since last time apparently it wasn't clearly understood. I hereby move that Chairman Marston take this duty over from the executive director and complete it amongst coordinated drafting with the other commissioners.
Is there any discussion on the motion? Can't hear you, Judge Roteman.
Procedure. Okay.
I'm sorry, I'm not hearing Judge Roteman at all. He's skipped. I heard about one word.
Can you hear me any better now?
Yes.
Yeah.
Okay. What I have to say is Commissioner Sheldon seems to be describing a process by which I thought that we were going to proceed. I think it's typical for, with the exception that the executive director has the role of advising us on how our procedure should go, since she's the one who has the expertise to advise the commission on how it should proceed or how it should not proceed. We can disagree with.
We dropped him. Is it?
I'm sorry, if anybody's talking, I cannot hear anything.
Janine says that the commissioners are unable to unmute themselves. So when Paul joined, he probably joined in a muted faction.
Yeah, I think we need to unmute.
And folks, hear me now?
There we go.
Yes.
Yes.
Okay. Hopefully you heard most of that. But let me go even shorter. It seemed that Commissioner Sheldon is describing a process by which I thought we were going to proceed with anyway, with the exception of, I think Ms. Greenstein, our executive director, needs to be involved in advising the chair on where we're at and where we're not at with regard to the statutes. We can disagree with that advice, but I think she still has a very important role to play, at least with regard to Marston. I do agree also that we should be involved in writing a letter if we're going to be inviting them. That's how I think we're going to proceed, and I do agree that it has been a little differently than expected.
Anybody else wish to be heard? Yes, Mr. McClintock.
Just a procedural matter. Well, one, I hadn't heard a second on this, but before we had a motion on the floor, and Commissioner Sheldon has raised a procedural objection to the meeting for lack of a proper agenda being posted. I don't know if he's waiving that in terms of proceeding, but I don't want to proceed with that hanging out there. So I think we need to clarify, since he spent a lot of time arguing over the notice process. If the meeting's not properly noticed, then the remedy is to renotice and reset it. So I just want to know procedurally, where are we? And I think it's Commissioner Sheldon's initial objection, and I just...
No, we clearly have waived that because we're all here and the meeting can proceed according to Marla. The rule though, states that an agenda must be issued. And I'm pointing out that we have issues. And those issues, I believe, are feeding in to, we talk about implicit bias here quite a bit. I feel that those issues are feeding in literally to this memo. I think the memo is off point, and we all have waived those issues. Otherwise, we would have voiced them. And my point in going back and forth on the email was trying to qualify. There was no need for this meeting. This is a baseless meeting, but we're here. We are all here on Christmas week, I might add, after many of us had had very long pandemic years.
So, okay, well, thank you for clarifying that, because you hadn't noticed that you had waived the objection. You spent quite a bit of time on it at the beginning of the meeting. And if we're speaking to the motion itself, I mean, obviously I voted against the motion the first time. One of the reasons why I voted against it was I believed it was not jurisdictional. I still believe that. And I think Marla's, you say it's unbalanced. I think it's a pretty straight recitation of the rule in our jurisdiction, which is a limited jurisdiction. I have to also take actually quite a bit of exception over the email traffic over the weekend. I don't think it's appropriate to debate things by email. I think since you're paying quite a bit of attention to the rules, it falls into the danger of, an unnoticed public meeting. So that's one reason, at least personally, why I chose not to respond to your emails. I will note, though, that you've stated that your motion has been mischaracterized, and yet in your emails, you posed a long list of questions that you thought should be raised at the meeting, which I do not believe were part of your motion. And one of the concerns I have about this whole process is it's veered from...
You're bringing executive session into this meeting. Please don't.
I'm just repeating what you had in your emails.
Yes, and I was simply noticing as we agreed in executive session. So if you'd like to remove ourselves and go into executive session, we can discuss this. But this is inappropriate. And Chair Marson, I expect you to enforce that.
All I'm saying is that your discussion today has veered from past communications, other communications. It's veered off. I'm not entirely sure exactly what the agenda is for the meeting anymore. And I still think it's very ill-advised. So
perhaps if an agenda would have been provided, we would know what was going on, Dawn. And no, this is no different. You're confusing in your mind the difference between the public session and the executive session. And I am troubled that you would bring executive session conversations into this. We had an agreement in executive session that I would...
Robert, do you need to respond to that? Do you want to go into private session?
No, we just simply agreed that I would advance questions, and that's what I did, Dawn, in keeping what was on the record. And we can review those tapes if we need to.
I'm repeating what you had in your emails.
And that was an agreed upon step because these people were supposed to come into executive session, and that's all I simply was advancing is what we agreed upon that I would do. Please do not further mischaracterize or attempt to defame what I just said.
Well, maybe we do need to go in executive session because I am totally unclear as to what your motion is, which I still think...
Here is my motion. Let me read it to you one more time. It's very simple.
Okay.
I hereby move that Chairman Marston take this duty over from the executive director and complete it amongst coordinated drafting with other commissioners. The reason I have constructed this motion in this manner is Marla begins her memo by apparently saying that she can't write this letter because of her own beliefs of what is going on. And that's why I made the comment that this is our decision, not the executive director's. I know she has reticence here. I don't understand that reticence because she's focusing on Rule 6, of which does not apply to what my original motion was. And Dawn, that is why I was asking for my motion in the previous meeting to please be circulated, because I think that this meeting has no purpose and justification, because if that motion would have been properly written down or recorded, we would not have a need for this meeting. Rule 6 doesn't even apply.
I believe there's a motion and there's discussion, but I haven't heard a second.
How many seconds?
I would second it just so we can continue discussion.
Okay, we have a motion and a second.
Can we have further discussion?
Yes, you can continue to discuss.
Could I chime in?
Yes, go ahead. Judge Carey.
Okay. Thanks. Well, I oppose the motion that's on the floor. I want to say that I thought Judge Marston phrased what I understood the motion that was voted on at the last meeting in an appropriate way. That's what I thought I was voting for. I want to restrict my comments now because I regret my vote for a number of reasons, but I think those would be better stated in executive session because they might be based on other things that happen later in the meeting. That's really all I have to say at this point.
Anybody else wish? Yes, Jane.
Jane will need to be unmuted.
There you go.
I just wanted to say that I do appreciate the research that took place after our meeting because jurisdiction is fundamental, and anything we do without jurisdiction is basically void or of no effect. So I do not have a problem with the meeting today, and I don't have a problem with our executive director's research and input to us. And I think, that's all I want to say.
The jurisdiction is ours because of the appearance issues that the letter raises, and they are outside of their bounds, as other commission members stated previously. And that's why I believe that this is jurisdictional. It's where the statute remains quiet that we are practicing because the Supreme Court has chosen to get outside of its own guidelines.
So I haven't seen the pushback from the executive director that's being referenced other than the memo that was sent to Chair Marston. I haven't felt her reticence was the word that Commissioner Sheldon used. I haven't felt it regarding the commission's decision to invite the state Supreme Court to a conversation with the understanding that they can decline in executive session. That was what I understood I was voting for. And I believe that's what the executive director was responding to in her memo that went to Chair Marston, who then called this meeting. So unless I'm missing something, I haven't felt her pushback to the writing of this letter. So unless you're privy to something I'm not, or I missed something, I don't see it.
I think the memo speaks clearly to that this is envisioning a public session for the Supremes to come before us in. It references Rule 6, which is all about public.
Okay, so
and so by effect, the memo states that nothing should happen, and the entire case that she makes is through Rule 6, which I disagree with. I think, as her memo further states, statute and rules are quiet on this, and it's for us to rationally reason through. Because of the very high amount of traffic we've had of criticism, of letters written and other things. I think Judge Rotman previously in the last two meetings has mentioned the same. Because of this high traffic, we need to at least make this effort to visit with the Supremes. That's my position. And I think that to simply say Rule 6 says, or is unclear that this isn't within our jurisdiction, that we just automatically shouldn't do it. I disagree with that. And I think it shows a reticence. I don't know of a better term to describe why you would write something that's not even related to what my motion was that was then passed.
So if Rule 6 applies only to public session and not executive session, if that's the case, then it doesn't apply. The motion as it was before that we voted on our last meeting would stand, and the letter would be written collectively between Chair Marston and the executive director. And there would be no reason, in my mind, for Marla Greenstein to recuse herself or to surrender the role, or for Chair Marston to take over the letter writing in conjunction with other commissioners. It seems that we've already voted. If it's decided that we do in fact have jurisdiction, which was the question with that memo, and if we do have the jurisdiction as decided by this commission and we move forward, I don't see the purpose in it being the responsibility being taken from the executive director.
I thought Marla was attempting to communicate with us that she did not want to write this. In the previous two meetings, both the one we just had and then the one previous to that, which I can't remember which month it is because of our delayed process here. In both those meetings, I believe that she felt that this was not jurisdictional 100%, just like she felt that we had no jurisdiction over reviewing the Chief Justice's prior letter earlier this year, which he later said, yes, there's an appearance issue here. And so it's along those lines that I believe that there is reticence. And if she doesn't have a problem writing the letter, but collectively with all of us, I don't think she needs to be removed either, but maybe we should hear from her.
In response to the delay, though, I would like to add that when you first presented this, and that brought to my attention on the commission, it was suggested and quickly agreed by you, Commissioner Sheldon, that we do table it until our next meeting. So I don't feel like we've had this major delay in process.
It was so Marla could do the research. I respect her, like I said last meeting, implicitly. This I have severe indigestion over, but it was so Marla could do her research. And I was a little surprised when we entered the last meeting with zero research being presented in front of us other than the statement.
Go ahead, Jane.
There's been discussion about the Rule 6, but it really seems like it's a Alaska statute, the 2230.01.011 on our powers and duties. I thought in my mind, that's really what we need to look at. And that statute's pretty clear that we take up written complaints or based on our own motion to into an allegation of a judge doing something wrong. And I don't think that was what the motion that was passed at the last meeting didn't fit into this section. And as much as it may seem unfortunate, there is no catch-all general grant of authority. And so while I voted in favor of the motion, I want to do things right. And I appreciate being redirected to what exactly are our powers and duties. And it would have been very easy for the legislature to put a catch-all in here to allow us to take something up, but it's clearly supposed to be driven either by a motion that we make to officially take up an inquiry or take action on a complaint that's filed.
Well, actually, then we need to go revisit several decisions we've made in the past where we've actually done this very thing. And those things were done in executive session, and we have audio to support that. We have done this repeatedly, and the rationale behind it is that it does matter that the appearance of impropriety issues be addressed. And we have always done that informally, just as I was suggesting here. That is something historically we do. It's something that's found riddled throughout our actual rules of how we take care of things to protect justices in general. And in fact, we have done that. Statutorily, they could have said quite a bit of things. Oh, I think he's addressing staff. We statutorily, they could have said a lot of things, but here's one thing that we do know from when the Alaska Commission on Judicial Conduct was formed. Here's what we know. We're the only check and balance on the Supreme Court. And the intent of the formation of this commission would be consistent with these previous decisions that we've all been involved with, well, some of us here have been involved with, in private conversations with judges, assessing what is an appearance of impropriety and then moving on and probably just dropping it after we say that. It's basically a, hey, are you really aware of what you've done here? That's what the conversation is. And we've done that repeatedly.
Anybody else have any comments?
I guess I'll leave it alone. I think I stated my position earlier, but the one thing that I find troubling about the discussion is, I mean, Robert, you keep jumping between our public venues where what you say, I think, has not been the case, and what we do in executive session, which we're not in now. And I don't think you can jump from one venue to the other as adroitly as you have. And so anyhow, I think the motion's ill-advised, and I'll just leave it at that.
Okay, well, I'd like to address that, Chair Marston.
Go ahead. Go ahead.
Thank you. I'm not jumping between. You all know I have extremely good memories for conversations, and it has served us all very well in the past. I'm not jumping between. And that's why I asked explicitly for a review of last meeting's tapes be made to develop what the motion actually was. And that simple step, which is one of the first things I asked for, would have solved a lot of issues. I'm not jumping around, and I don't appreciate that being an attempt at reframing either.
Well, so we have a motion on the floor that's been made and seconded. I think and let me make sure I state it correctly. Please correct me if I misstate your motion. I think the motion dealt with who was going to draft the letter. The question is whether Marla would draft the letter or I would draft the letter in conjunction with commission members. And your motion was to not have Marla do it, but have me do it.
Paul Roman. Join the meeting.
Is that an accurate statement of your motion?
My motion is as follows. I hereby move that Chairman Marston take this duty over from the executive director and complete it amongst coordinated drafting with other commissioners. That's my motion, pure and simple. And so that I am not mischaracterized, as has been attempted a couple of times here as well as even leading up to this meeting. That's why I continue to read it verbatim and why I actually did prepared remarks this time.
I just have concerns about the fundamental, Marla's concerns about not having jurisdiction. I mean, we can vote on your motion, but it still comes back to this letter, whether this letter should go at all. If we do not have jurisdiction, then we don't have jurisdiction.
Oh, yeah.
And
I agree. And so my 2 points here is we have jurisdictionally other than Rule 6, and then the statute that is referenced, we have jurisdiction because we are the only check and balance on the Supreme Court. And there is an appearance issue here that we traditionally, and accepted by the Supremes, by the way, we've made these approaches and they have accepted them. So we have precedent. So I think there's not only jurisdiction, but acceptance of our policy, procedure, and processes. So with that, maybe we should just vote.
vote on your motion or vote on the original motion. To me, people find that there is a jurisdictional error and that we don't have the ability. Why would we be going forward in something where we have no jurisdiction?
Because I just made the case of why we do. Literally, Chair Marston, we have done this repeatedly before. If we vote and find no jurisdiction, we're going to have to unwind a number of items, and that is going to create a tremendous amount of work, because I will insist on that step because we have done this repeatedly before. So if you want to deny what this body has done repeatedly in the past by ruling we don't have jurisdiction to have informal conversations when we are troubled by issues, we can get that precedent set today.
Well, we don't seem to have a motion on the floor to reconsider our previous decision. All I have is Marla's opinion that it's questionable.
You also have my opinion that it's not questionable.
Right. And people,
And-
individual, lawyers and everybody, who knows? I don't know what everybody's opinion is, but I don't think there's a motion to reconsider the previous one on the floor at this point.
And since we somewhat follow the rules, I think only the people who voted for the motion last time would be the ones who could move to reconsider.
Actually, there is no reconsideration of vote in the last meeting. This would be a brand new motion, Dawn. Our rules require that a brand new motion be made. Earlier votes cannot be revisited. I painfully made myself re-aware of all of our rules because of this process last week.
Are we able to table the current motion that's on the floor and visit whether or not this commission agrees that this is jurisdictional or not, which I thought we were actually voting on last time. And it was determined 5-3 that it was jurisdictional. My opinion hasn't changed. I do think that this commission has jurisdiction if it's executive session for a private conversation and it's not a public investigation where we're naming judges, which seems pretty clear in that, even that Rule 6. My opinion hasn't changed. I don't know if anybody else who voted in favor of the motion, their opinion has changed, possibly. But it seems to me that we do need to table the current motion on the floor and revisit if we're going to do that. Because I did agree with the chair that we can't make a vote on a motion to write a letter if it's determined now that we don't have jurisdiction.
I will not resist the tabling of this motion.
Okay.
I would argue, Commissioner Sheldon, that it will fail as it stands to do something. I would encourage you to reconsider that so we could revisit whether or not.
No, that's what I'm saying. I do not resist your motion to table my motion. I'm with you.
Thank you. I misunderstood with the Zoom delay.
So anybody not in favor to table the current motion so we can address the other issue of jurisdiction? Okay, Mr. Sheldon's motion is tabled for now. Do I hear discussion on the issue of whether we have jurisdiction to send a letter to the Supreme Court?
Commissioner, before we do that, I think that's really a conversation that should be done in executive session. So I move that we move to executive session. If we're going to
second it.
Motion's been made and seconded to go to executive session. Alita, can you do that for us?